Ladies and gentlemen, welcome to Civil Justice Subcommittee for Wednesday, March the 11th, 2026. We'll be taking roll. All members sign in and indicate that you're present. Mr. Clerk, you recognize.
Mr. Chairman, you have 5 members present. You have a quorum.
All right, members, we got a quorum. Do we have any personal orders? Seeing none, we will jump right in the calendar here. We're going to take care of item number 4, House Bill 1915 without objection, taken off notice. Item number 5, House Bill 1855 without objection, taken off notice. Item number 6, House Bill 2155 without objection, taken off notice. That brings us to item number 1, House Bill 1704. Do I have a motion? And I got a motion and a second. And Deputy, I'm sorry, I'm looking at the wrong calendar. Let me reconsider our actions here. Item number 1, House Bill 1872. We got a motion and a second. And Deputy Speaker Zachary, you are recognized, and I've got 2 amendments.
Yes, sir, Mr. Chairman. I've got, I don't know which one you have first, but I've got 14443.
And are you going to add both of them?
Yes,
Okay.
yes, sir.
So we had a motion and a second on 014443. All those in favor of adding 1443 to House Bill 1872 signify by saying aye. Those opposed signify by saying no. The ayes have it. Amendments added. And members, we got an untimely filed amendment. And since it's so late in the session, do we have a problem considering that? Do we have a motion? We got a motion and a second. And what's that drafting code?
Thank you, Mr. Chairman. It's drafting code 15484.
15484. All those in favor of adding 15484 to House Bill 1872 signify by saying aye. Those opposed signify by saying no. The ayes prevail. And we are going to roll it into one if without objection. So without objection, we will roll 14443 and 15484 into one. All right, Chairman Zachary, you're recognized on your bill as amended.
Thank you, Mr. Chairman, committee, and members. Thank you for your indulgence on the untimely filed amendment. This is directly from the AG, and they just got with us yesterday and said that we needed to ensure this aligned with current statute. So that was the reason for that. So thank you for working with me and being flexible, Mr. Chairman. And I did discuss that with Chairman Farmer as well. Members, the bill in front of you today is a fairly simple bill. It creates a civil cause of action against a healthcare professional by a person who suffered an injury as a result of a gender transition procedure. If that person has been coerced, we define coercion within the piece of legislation. There was an earlier version that made this retroactive that has been taken out. So it's only from this point moving forward. And the last thing, Mr. Chairman, there is a carve out from genital defects and puberty treatment by healthcare professionals. With that, would that answer your questions?
Great explanation of the bill. And first on my list is Representative Johnson. And the members, y'all can go back and forth.
Okay, thank you. It's a pretty simple question, I think. So these procedures are already illegal, correct?
You're welcome to go back and forth.
Thank you, Mr. Chairman. On a minor.
Okay, so how are they going to sue on something that doctors can't do and aren't going to be doing because it's illegal already?
Mr. Chairman, you said go back and
Yes,
forth.
sir.
I'm sorry.
Yeah.
So for minors, this would not apply unless a doctor illegally performed a procedure on a minor, because we have banned those. But those who are over 18, this would apply if they are coerced.
Thank you.
All right, members, seeing nobody else on the list, we're voting to send House Bill 1872 to the judiciary. All those in favor vote aye. Those opposed vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, takes vote.
Mr. Chairman, you have 5 ayes, 1 no.
The ayes prevail. Judiciary.
Thank you, Mr. Chairman. Committee.
As amended. All right, next up is item number 2. We're going to, without objection, go to item number 3 because the sponsor's not here. We got a motion and a second on House Bill 181 by Representative Moody. Chair Lady Moody. And I do show an amendment. Would you like to run that?
Yes.
What number do you show?
Excuse me. Yes, I have 014903.
I show 14903. All those in favor of adding 14903 to House Bill 181 signify by saying aye. Those opposed, no. The ayes prevail. And Chair Lady Mitty, you're recognized on the bill as amended.
Thank you, Mr. Chairman and committee. What this bill does is so simple. It's extending some dates. So we're changing the deadline for the task force, which is the advisory task force to review the composition of Tennessee's current judicial districts. So this will help them to complete their findings and recommend publish a proposed statewide judicial redistricting plan to the legislature. It changes from January 1st, 2027 to January 1st, 2028. And it also changes the deadline for the General Assembly to reapportion the judicial districts from December 31st, 2027 to December 31st, 2028. And this 1-year extension will allow this task force additional time to complete their task. And that's what our ask is.
Very good presentation. Representative Johnson, you're number one on my list.
Thank you. After reading through the calendar today and seeing that there are multiple bills about requesting another judicial district. And so, in all of this, I'm thinking that seems a very piecemeal way to do it. Why don't we redistrict or, so I like that your bill is getting to that. It's unfortunate that it's a few years out
Right.
because I feel like instead of all this piecemeal, we should be doing that right now. But
Right.
thank you.
Thank you.
Thank you. I don't have anybody on my list. We're fixing to vote, but I just want to say Representative Johnson brought something very important up that we read these bills prior to coming up here and these amendments. I appreciate every committee member doing that. So all those in favor of sending House Bill 181 to full judiciary, vote by aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 0 noes.
The ayes prevail. Full
Thank you,
judiciary.
Chairman and committee.
Next up, item number 4, House Bill 1915 by Chairman Boyd. That was taken off notice, so we'll go up to item number 7, House Bill 2251 by Chairman Grills. We got a motion. Do we have a second? Need a second going? We got a second. Chairman Grills, you are recognized.
Thank you, Mr. Chairman and committee. I got this bill late yesterday afternoon, and what we're trying to do is create a pilot program to allow counties to opt in, the 10 busiest counties judicially, according to the comptroller, to create a magistrates and with the county commission. They can pass a resolution, create the magistrates, and let them handle class D and E felonies and misdemeanors to help the judicial process speed up.
Good description of the bill. Do I have any questions or comments? Representative Johnson, you recognize?
Yeah, this was one of the bills too that what I was talking about that we need that study for because a lot of areas are having problems. I guess the one thing that I heard from some, and not from everybody, but some feel like a magistrate's not as qualified. But these magistrates will be seeing lower level because they're not judges. They might be accomplished lawyers, but not judges. But
That is correct.
thank you.
Thank you. Members, we don't have Representative Davis.
Thank you for doing this. This is going to help create a huge burden off of a lot of workload that I know in Knox County we have some backlog, so I appreciate that. But this is permissive as well, correct?
That is,
You're free to go back.
yeah, thank you, Mr. Chairman. That is correct, and the county will decide if they want to, and if they don't want to, they can obviously not.
Thank you. Thank you for bringing the legislation.
Thank you. We're voting. All those in favor of sending House Bill 2251 to full judiciary signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. Judiciary, thank you. Next up, we're going to be skipping item number 9, going to item number 10, House Bills. Hold on just one second. Okay, Chair. Okay, I'm sorry. I was looking at a different one. Item number 9, HJR, correction. Item number 8, HJR 805. Chair Lady, okay, you're recognized on your bill.
Thank you, Mr. Chairman and members. HJR 805 proposes amending Article 6, Section 4 of the Constitution of Tennessee to require judges of the circuit, chancery, and other inferior courts to be residents of a county of their respective circuit or district, rather than residents of the circuit or district to which that judge is to be assigned for 1 year prior to election. In 2025, the General Assembly approved House Bill 490, Public Chapter 487, which established that the residency requirement for a municipal judge with concurrent general sessions jurisdiction, as ruled in McNabb versus Harrison, would apply prospectively beginning at the next regularly scheduled election, which would be 2030. There are currently 27 municipalities across the state of Tennessee who have city courts with concurrent general sessions jurisdiction. The problem is that several of these municipalities are very small and do not have licensed attorneys residing within their city limits. This puts significant stress on the county general sessions court, who must absorb all criminal cases from the municipal court. This defeats the whole purpose for having municipal courts with concurrent general sessions jurisdiction, because they help alleviate the caseload for county general sessions courts. HJR 805 will alleviate these issues by allowing the judge to reside in the county and not just the circuit or district. With that explanation, I stand for questions, and I do have someone here to testify that can explain what brought this all about.
Thank you. Do we need to hear testimony, or is the committee ready to vote? Okay, without objection, we'll go out of session. And that is Mark Litchford, City of East Ridge. Come on up and just say who you are and who you represent, and you'll have 3 minutes.
Thank you, Mr. Chairman. Members of the subcommittee, my name is Mark Litchford. I am the city attorney for the City of East Ridge, one of municipalities in the Hamilton County that does in fact have a concurrent jurisdiction municipal court. The City of East Ridge actually does not have a resident attorney residing in that municipality. And when the McNabb case came about, it would have been valid, at the time, it would have rendered our current sitting judge to have to be vacated. We also have just recently had a passing in Collegedale of Judge Wilson. They had 3 applicants apply to be replacements, but only one was a resident at that point. And so the challenges of these small municipalities is that there's just not a qualified candidate quite often. Again, that's 5 in Hamilton County, 27 across the state. The big issue that we've also had is that when we had positions in Hamilton County that could not have a city judge preside over that. This again also has happened in Red Bank, where we've had a judge have to take disability. It puts a ton of pressures on the local general sessions judges, because they then have to fill in. And most of the municipality courts occur at night after hours of the regular county ones. And so we've consulted with the general session judges. They were in support of this bill because it will allow them to know that these courts are being covered in a situation where they would otherwise have to absorb the intensity of these cases. And so that is why we were in support. This came about as a result of a Supreme Court holding last year. And I think the holding made sense, but the problem is that it was interpreted that the term circuits and districts of the courts of which they preside meant the city and not the county. And this would simply just allow that they be required to be a resident for 1 year of the county in which the municipality resides.
Thank you. And Representative Johnson, you recognize.
Yeah, I would just say thank you for being here, and thank you for that explanation, because somebody had told me it had something to do with Chattanooga, and I was like, how can this happen in Hamilton, but a municipality? So thank you so much for explaining that. I appreciate that.
Yes, Representative Johnson.
Thank you. I do not see any other questions. We appreciate your testimony today. Very good.
Thank you.
Thank you. Members, without objection, we'll go back in session. And would the sponsor like to follow up or close, or?
I would appreciate your support and vote on this bill.
All
Thank you.
right, members, we're voting to send HJR 805 to the full judiciary. All those in favor vote aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 1 no.
All right, bill passes.
Thank you.
Thank you.
Thank you, Mr. Chairman and committee.
That takes us to item number 9, the one that I thought was taken up a while ago, but I got mixed up. Okay, 1923, without objection, be rolled to the March 18th special calendar. Item number 10, House Bill 1798. Representative Reeves, are you running this? We got a motion and a second, and Representative Reeves, you're recognized on House Bill 1798, and I do not show any amendments.
That's correct, Mr. Chair. Thank you. May I speak on the bill?
You can.
Okay, thank you. So this bill simply clarifies Tennessee law to remove confusion about how fees are paid to sheriffs or other officials for serving garnishments. Currently, it's unclear whether multiple garnishments in the same case qualify for separate service fees, which has led to inconsistent practices. And the bill established that each garnishment is treated as an original service for fee purposes, and that ensures that sheriffs and authorized process servers are compensated for the time, labor, and administrative work required to complete each service. The bill also allows officials to require payment in advance, so they're not left absorbing unpaid fees. And that's what the bill does, Mr. Chair.
Thank you. Good presentation. Members, we got any questions? Representative Johnson, you recognize?
Yes, thank you. I think that $40 sounds like a reasonable fee. But it also sounds like it might be really work intensive for a $40 fee. Is that the case, or do they feel like this is going to cover things?
And y'all welcome to go back and forth.
Yeah, thank you very much. I think my sheriff who's in the audience would probably agree with you that is not very much, but they certainly don't want to be left absorbing one fee when they should have collected several.
Yeah, it just seems like paperwork heavy situation. Thank you.
Members, do we have any other questions for the sponsors? Seeing none, we're voting to send House Bill 1798 to Judiciary for all those in favor vote aye, those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. Full Judiciary.
Thank
Congratulations.
you, Chairman and committee.
Thank you. Next up is item number 11, and Chairman Farmer, you recognize.
Yeah, Mr. Chair, if we could roll House Bill 849 to the Hill.
With objections to order, 849 to the Hill. Brings us to item 12, House Bill 1707 by Representative Scarborough. And I do show an amendment, Representative.
Thank you, Mr. Chair. Yes, drafting code 013193.
13193 is what I show. All those in favor adding House or Amendment 13193 to House Bill 1707, signify by saying aye. Those opposed, no. The ayes prevail. You're recognized on the bill as amended.
House Bill 1707, this bill requires that all courts in Tennessee must cooperate with federal immigration authorities when they're enforcing immigration laws. In this bill, if a judge obstructs lawful federal immigration enforcement, they can be reported to Tennessee Board of Judicial Conduct, where the board can investigate the judge for judicial misconduct. And if such is found, it could be grounds for removal from office. In conclusion, this bill makes it clear the Tennessee courts must stand in line with federal immigration enforcement, or judges may face disciplinary action. That completes my
Thank you. Good explanation. And Representative Johnson, you're recognized.
Thank you, Mr. Chairman. Have we had a situation in Tennessee where a judge has refused to do something lawful in a situation like this?
I'm sorry, Representative, I can't speak to that. It's a new bill that we're trying to get in line with.
You can't tell me whether this is we're solving a problem or we're just writing legislation for something that has not ever occurred in Tennessee.
I'm not saying it hasn't occurred, or I don't have personal knowledge of it myself.
So what was the impetus for bringing the bill then? Because to my knowledge, it's never happened in Tennessee where a judge has refused to follow the law.
Quite frankly, what we're going to do is just kind of get in line with judges and our judicial system as we prepare and move on forward with immigration issues.
But don't we already have that they can already go to the Board of Judicial Review if they don't follow the law? Isn't that already something that can happen? I don't understand what we're doing new.
Sorry.
You don't have to, we can go back and forth,
Yeah,
he said.
you can go back and forth.
I am familiar with some of that, where judges could be faced judicial misconduct.
Mhm.
That could happen. In this particular case, I'm bringing this bill again, and so in the future, we are on the same page of what we're moving forward to.
I think we're already on that page. We already have all of those things in place.
I understand. I renew my motion.
Thank you.
Very good. Any other questions? Seeing none, we're voting to send House Bill 1707 to full judiciary. All those in favor vote aye. Those opposed vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 6 ayes, 1 no.
The ayes prevail.
Thank
Full
you, Mr.
judiciary.
Thank you, Mr. Chairman.
Congratulations.
Thank you,
As
members.
amended. That brings us to item number 13, House Bill 2184 by Representative Langford. Representative, you are recognized, and I do show one amendment.
Thank you, Mr. Chairman. Yes, I do, and that is 013729.
13729, that's what I show. All those in favor of adding 13729 to 2184, signify by saying aye. Those opposed, vote say no. Amendment added. You're recognized on the bill as amended.
Thank you, Mr. Chairman. In 2021, the General Assembly established a process where certain cases would be heard by a three-judge panel. When that legislation passed, it required that the venue be where the plaintiff resides. This bill would change that venue for the three-judge panel to any county within the state. It would also allow the Supreme Court to choose one judge from each grand division. Current law allows the court to choose two judges to assist the judge where the case originated. And lastly, it would increase the minimum time frame from 15 to 90 days to give the court the General Assembly time to fix any redistricting plan defects. And that's just a practical change because we can't pass a bill in 15 days. It's rather hard to do that.
Thank you for that explanation. Members, do we have any questions for the sponsor? And Representative Johnson, you're number one on my list.
What is the impetus for this bill? I'm a little confused about why you're going to take it out of the plaintiff's jurisdiction.
I'm sorry, y'all can go back and forth.
Oh, okay. Yeah. So lawsuits are prevalent around the state. And what we're finding is that when someone files suit, you're dragging the person you're suing back to your home county. So it just allows the flexibility to do it in different counties.
Thank you.
All right, members, I do not show any other questions. We're voting to send House Bill 2184 to full judiciary. All those in favor vote aye. Those opposed vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 1 no.
The ayes prevail. Full judiciary, congratulations.
Thank you, Chair and Committee.
Thank you. Next up, item number 14, Representative Love, House Bill 1949. Well, he's not here. Without objection, we'll roll that to the hill. Next up, item number 15, House Bill 2432, Representative McKenzie. And I show an amendment. Do we have a motion? We got a motion and a second, and I do show an amendment. Would you like to add that?
Yes, Mr. Chair. That amendment number is 015065. Thank you.
Okay, we got a motion and a second on the amendment. We're voting to add 15065 to House Bill 2432. All those in favor signify by saying aye. Those opposed say no. The ayes prevail. You're recognized on the bill as amended.
Thank you, Mr. Chair. Just to get to it, the impetus for this bill came from a Knoxville constituent, Michelle Lawson, Knoxville native. She lost her son in a tragic accident following the UT football game. And not to go into the details, but he was killed instantly by the driver who was allegedly under the influence. The grieving process was extremely difficult, as you can imagine, for Ms. Lawson. So about 18 months after her loss, she began to make inquiries and start to dig in and found credible inconsistencies in the narrative. And so while she and tried to pursue this truth, she was told that the statute of limitation was 1 year and the police could no longer investigate. So, Tennessee ranks 13th in pedestrian fatalities per 100,000. A traffic organization, as you all know, it's extremely high. Basically, a person is killed every 83 minutes in a traffic crash. This met with no opposition in the Senate. This would, the amendment would extend, and this is just to get us in line. We initially just wanted it for 2 years, but they said for vehicular homicide, this would be a 10-year statute of limitation increase, and that's what the department asked us to.
Very good explanation of the bill as amended. Any questions for the sponsor? Seeing none, we are voting to send House Bill 2432 to full judiciary. All those in favor vote aye. Those opposed vote no. So every member voted. Does any member wish to change their vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. Tell Ms. Lawson we'll be praying for her.
Thank you. Thank you, Mr. Chair and Committee.
Thank you. Next up, item number 16, House Bill 2144. I didn't see him. We'll reconsider our actions and go back to item number 14, House Bill 1949 by Representative Love. Do I have a motion? I got a motion. Do I have a second? Need a second going twice? We got a second, and I do show an amendment.
Thank you, Mr. Chairman and committee members. The amendment is number 015039.
15039 is what I show. Do I got a motion and a second on the amendment? Need a motion? We got a
Travis.
motion? We got a second?
Thank
You're
you.
recognized. Oh, let's add it. All those in favor of adding 15039 to House Bill 1949, signify by saying aye. Those who say opposed, say no. The ayes prevail. You're recognized on 1949 as amended.
Thank you, Mr. Chairman and committee members. We all know how much the opioid crisis has had an effect on our communities. And many of our nonprofits have engaged in trying to help alleviate the ramifications of the opioid crisis. The issue sometimes is that their grants are reimbursement only. And this bill simply says that the council in advance notice can consider at some point advancing a portion of their grant award to some nonprofits so they can do some of the work in advance of what they have been trying to do. That's what the amendment says. And there are members here if you want them to, well, they're not on the list to testify, Mr. Chairman, never mind. I'm sorry about that. But that is the background of the bill.
Excellent presentation. Members, we got any questions for the sponsor? Seeing none, we're voting to send House Bill 1949 to full judiciary. All those in favor vote aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, takes vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail.
Thank you, Mr. Chairman, committee members.
Congratulations.
Thank you.
All right, members, without objection, that's going to be as amended, by the way. Members without objection, we'll take up item number 18, House Bill 1964 by Chairman Farmer. We got a motion and a second. Chairman Farmer, you're recognized on your bill.
Thank you, Mr. Chairman. I make a motion to go into recess.
Well, so ordered without objection, we go to recess.
Thank you.
Just to clarify, it'd be a 5-minute recess. All right, members, we want to do item number 2, House Bill 2272 by Chairman Crawford. Let's go back in session first. All right, item number 2, House Bill 2272 by Chairman Crawford. We got a motion and we got a second. And I do show an amendment, Chairman.
Yes, sir. Code 015386.
15386, that's what I show. All those, we got a motion and a second. All those in favor of adding 15386 to 2272, signify by saying aye. Opposed, no. The ayes prevail. Chairman, you're recognized on the bill as amended.
Thank you, Mr. Chairman. Thank you, committee. This is known as the Dolly Parton bill. And it doesn't do what you think it's going to do, for sure. But what this bill is doing, it's addressing a problem that we've had over the last few years with celebrities being able to use their name for different things. This is kind of like an NIL deal. They can sell their names, the rights to their names, but they really don't have anything to do with the company. And the reason it was brought to us is Dolly has a wine that she has kind of got a business deal with, and she's going to allow them to use her name, and it's going to be in Dollywood. And this bill would take the liability off of them, since they have nothing to do with the brewing or any of that kind of stuff. We're just using her name. That's what the bill does. Stand here for
Excellent.
questions.
Excellent presentation. Members got any questions? And Representative Johnson, you're number 1 on the list.
Okay. Thank you. So that situation, I understand. So somebody else brought another situation to me. Well, first of all, one of the questions was, should we have a carve out for celebrities? And is that giving them special privileges that we don't give to others? And the other question would be, like in a situation where we have some bars, there are some bars in Nashville that are owned by celebrities, but what if the celebrity shows up in their bar and throws a stool off the thing and hurts somebody? That it doesn't limit that, right?
And y'all welcome to go back and forth.
Yeah, thank you. It does not. The liability still would be on him, especially if he owned the property. So I said him, I should say whoever.
These are mostly men down here.
But the best way I can describe this is it's kind of like an NIL deal.
Mm-hmm.
And that's exactly what this bill is basically creating, is a
Right.
way for them to be able to use their name but not have the liability.
Well, thank you. And I do support that, but I just had those questions. And do you feel like this is a carve out for celebrities that a regular person wouldn't have?
Again, it's like an NIL deal. We've got sports people, famous basketball
Right.
players and all
Celebrities.
them. They're still celebrities, and we're not carving them out. It's just basically the same thing.
Thank you.
Yes, ma'am.
Thank you, Representative Davis. You're next on the list.
I'm good. Thank you for bringing it.
Thank you. I don't show any. Representative Travis, you got anything?
Thank you, Mr. Chairman. Question on the bill.
Question's been called. Members were voting to send House Bill 2272 as amended to the full judiciary. All those in favor vote aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 2272 goes to full judiciary as amended. And you tell Dolly we're working 9 to 5 here too to get this stuff passed.
I understand that completely. Well, the next time you see me, I hope I've got some pink lipstick right here. So,
There you go.
thank you, Chairman. Thank you, committee.
Thank you. Members, give me 1 second to look at the calendar here. All right, members, that brings us to item number 18, House Bill 1964 by Chairman Farmer. Do I have got a motion? We've got a motion and a second. Chairman
Second.
Farmer, you're recognized on House Bill 1964.
Thank you, members. Mr. Chair, what this does is provides for a mechanism to give part-time general sessions judges a pay raise. They haven't had one in 2 decades, and their work continues to pile up. And That's what this bill does, and I'd move passage.
Excellent explanation. Members, I do not see any questions. We're voting to send House Bill 1964 to full judiciary. All those in favor vote aye. Those opposed vote no. Does every member vote? Does any member wish to change the vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. Full judiciary. Next up, item number 19, House Bill 2494 by Chairman Farmer. We got a motion and a second. Chairman Farmer, you're recognized on the bill.
All right, thank you, Mr. Chair. Members, what this bill does would provide for a pay raise for our Supreme Court, Appellate Court, State Court judges, and it would go into effect in 2030, I believe. They can't take a raise in their term, so that's what this bill does.
Can't get no more direct than that. I don't show any questions. All those in favor sending House Bill 2494 to full judiciary vote aye. Those opposed vote no. So every member voted. Does any member wish to change their vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. Full judiciary. All right, members, we're going to take a 2-minute recess to try to get some bill sponsors down here. Without objection.
You going to stay? You going to stay? You going to stay? State and local? What committee you going to? Child something? House Consumer Affairs, okay. All right. I'll be right here. I'll save your spot.
Number 20, and they're on 5.
All right, members, we're going to go back into session. Chairman Russell has stepped out to run a bill, and it is that time of year. So I believe that brings us to item 17, House Bill 2605 by Representative Salinas.
Motion.
Second.
And you have a motion and a second. I'm not looking at any amendments here, so you are properly recognized.
Thank you, committee. Well, it's been a crazy day. This bill came to me as an idea from a local business owner in Memphis. Some agents came into his establishment and he asked them to please leave because he was scaring the customers that were there. As we've seen, ICE interactions have become very heated. They have caused a lot of turmoil, a lot of damage. And this is only one example of the presence of ICE, how presence of ICE and other law enforcement that is part of the Memphis Task Force is negatively impacting our business community. I'll remind you that our business community and many of these restaurants that have come and talked to me are owned by U.S. citizens. So these damages are sustained by U.S. citizens. Their profits are being hurt. So what this bill aims to do is try to give them the ability to sue ICE if a result of them has caused injury, death, property damage to their business or themselves.
Very good, and thank you for that explanation. First on my list, I have Chairman Todd. You recognize.
Thank you, Mr. Chairman. You mentioned damage to businesses. What, I assume you're talking about physical damage. What physical damage has been done in Memphis?
So there have been instances where ICE has forced their way in, and we have seen windows be busted or doors pushed forward. So most of the time it's when they're forcing their way in. Those are the types of damages that are physical. There are other damages that aren't physical that you didn't ask me about, but they're there.
Okay, are those, I assume that damage you're talking about, if they had to break in a door or window, someone illegal or that may have committed a crime that they were after was on the other side of that door, and this is in the normal operation, just like any law enforcement agent would do?
Not necessarily, because some of these have happened without judicial warrants, and many of these businesses have been trained to ask for those judicial warrants. They are aware of the law that they do have to open and let people in if they have signed judicial warrants. And what we have seen in videos is them asking to show the signed judicial warrant to see if that they have an employee there or a customer that may have that name that from that judicial warrant, but judicial warrants have not been presented. So from the example that you gave, I have not seen, to my knowledge yet, a signed judicial warrant where the agent had a signed judicial warrant for a person that was present there that was denied entry and then forced their way in.
Can you give me the name of a business where this has happened in Memphis, where someone from law enforcement has entered without a warrant?
I don't have the name of the business, but I can get it to you. I've seen videos. The business that I've specifically that I'm referencing is the sandwich place. And he was also trying to get answers from the law enforcement and asking these questions. He's like, who do I need to talk to? Who do I need to talk to? And he really wasn't given those answers. As a result of that, then more troopers came and more law enforcement. I'm not sure on the details of whether it was MPD, Tennessee Highway Patrol. I don't know, but this is well documented. It has been in the news. That's how I found out about it first. But no one really provided him answers at all.
Well documented, but you don't have any details. I appreciate that. I find it odd that law-abiding citizens would get nervous or afraid when law enforcement enters a room. That just doesn't happen. So I appreciate the indulgence, Mr. Chair.
Tyree Nichols was killed in Memphis. Martin Luther King was killed in Memphis.
Yesterday?
I'm not talking about yesterday. Tyree Nichols was recent by Memphis Police Department. That happened.
All right,
So-
any additional questions?
Yeah.
Okay, Representative Johnson, you recognize.
So in addition to property damage, like some of the damage I saw was that all of these folks were standing out there, and it did prohibit people, even part of the time they were blocking the entrance from the street to the business. That was happened by so many law enforcement. So we're also talking about loss of income, correct? Because people were not able to even pull in to the sandwich shop or these places.
Yeah, and there were lights going, and that's why I say that I don't know the details. I don't want to get it wrong. I don't want to say it was MPD that was there.
Right.
because you couldn't
Sure.
really tell. Or I don't want to say it was Tennessee Highway Patrol that was there, but you could tell that it was law enforcement that was there and that
Mhm.
was on the parking area. So it would inhibit people from being able to park and access the business. So there is a loss of profit as well.
Right. And there are people that have had some really traumatic or know people with traumatic experiences that, yes, does them make them think twice about being around law enforcement. And if we're going to pretend like that doesn't happen, and from people who are totally within the law, you're being intellectually dishonest if you are acting as if that's not a real concern because of folks like Tyree Nichols. So thank you for bringing this.
Very good. Members, any additional questions? Representative Salinas, you recognize.
Yeah, and I don't talk about this often, but I did have a negative impact with police when I was in college. And I parked at a handicap spot and I was supposed to be there. I had a sticker and I was harassed. The police officer, he said, "Give me the ticket, give me the ticket." He's like, "That's not yours, you're faking it." And he was in my face. And I was like backed up to the car. And I said, "It's mine, it's mine." And then he didn't stop until I pulled up my pant leg and showed him my brace because I'm a cancer survivor that had bone cancer and my mom is in a wheelchair. So I would never park. And that was over a sticker, a parking sticker. He could have just asked me, "Hey, are you supposed to be there?" But it was immediately escalated.
Yeah, well, thank you. I think we really have to understand that our situation is not the same for everybody else. And everybody else, it's very possible that they had legitimate traumatic experiences and want to avoid that at all costs. So thank you for pointing that out.
All right, members, any additional questions for the sponsor? I don't have anybody else on the list. Question's been called. Any objection to the question? All right, seeing none. Members, looks like we're voting to send House Bill 2605 to full judiciary. All those in favor vote yes. Those opposed vote no. Has every member voted? Any member would like to change their vote? All right. Mr. Clerk, Madam Clerk, Mr. Clerk, would you take the vote, please?
Mr. Chairman, you have 1 aye, 4 noes.
All right. House Bill 2605 fails. And we have item 16. We have House Bill 2144. If we had Representative Glenn, he is not here. And that's okay because we're running out of time anyhow. So members, what we could do without objection is roll all remaining bills to next week's calendar. And I would take a motion to adjourn. Very good. All right, cool. All right.